back, everybody, to the Law&Crime Trial Network. I'm Rachel Stockman, alongside Linda Kenney Baden, who will be my expert guest, and also she'll be hosting later, so we'll have lots of Linda today. I'm sure everyone's very excited about that. Okay, we are at a brief break, lunch recess, in that trial that we've been following out of Iowa against Cheyanne Harris, the case of a mother accused of murdering her 4-month-old little boy. Let's take a look more into this case. A young Iowa mother faces first-degree murder and child endangerment charges in connection with the death of her 4-month-old baby, Sterling Keene. Sterling was found dead and covered in maggots in his baby swing on August 30th, 2017. Authorities say the baby had not had a diaper change, bath, or been removed from the seat in over a week. The parents, Zachary Keene and Cheyanne Harris, are charged with baby Sterling's death. Authorities first responded to the home that morning after Keene called 911.
And she come in and woke me up and said to stop.
Okay. Cheyanne did?
Yeah. So I got on the phone and called y'all right away. So I was a little disorientated and then woke up and told my son's dad.
He claimed the baby was fed at 9 a.m. that morning and was in good health. But when they checked on him just a few hours later, he had died. The medical examiner ultimately ruled the death as a homicide caused by failure to provide critical care, after an autopsy found maggots in various stages of development on the infant. The baby also had an extreme diaper rash and caused E. coli to enter into his bloodstream. Zachary Keene testified at his trial in November, which we showed here on the Law&Crime Network. He said that Harris was the primary caretaker of the child. Keene was ultimately found guilty after about an hour of jury deliberations and sentenced to life in prison. He is now seeking a new trial. If convicted, Harris also faces life in prison, the mandatory sentence for first-degree murder in Iowa. I'm Rachel Stockman for Law&Crime Network. Okay, so as I mentioned in that piece, Harris's attorney filed a notice to use diminished responsibility or the intoxication defense to try to chip away at this first-degree murder charge. Linda, tell me how this works, and using your expertise, looking at the facts surrounding this case, do you think it could possibly be successful?
Well, I think that I would use the facts if I were her defense attorney, forget the father, to say it is so egregious, there's clearly something wrong with her. Obviously, I listened to you as I was coming in, Rachel, and I heard the testimony that the hospital, when the baby was born, he had meth in his umbilical cord, so they knew she was a drug addict at that time, and then just let her go. Some states would arrest her at that point for child abuse. Obviously postpartum depression is a consideration, and we've seen cases, the Andrea Yates case in Texas, where that was clearly, it clearly is something that just affects the mind of somebody who's just given birth. So that's that's how you chip away. And
we listened to the defense's opening. I don't know if you get it.
I did.
You caught it. You might have missed it because it was so quick. But you can really tell, obviously, that's where they're going with this defense. And what they're trying to say is, listen, they had no other issue with this other child. It was this child that was neglected, and no one else.
Right. And so either something was wrong with the mother, or there was some dynamic with the father and the mother. And I've always suspected in this case, because they did a DNA test, that the father may have thought, maybe that child is not mine.
It's not mine. Okay. Let's listen, and we'll get to some of the defense's opening, but let's listen first to the prosecution.
Malnutrition, dehydration, infection caused by E. coli bacteria. That's what caused Sterling's death. Ladies and gentlemen, the evidence in this case will show that the defendant, Cheyanne Harris, was a stay-at-home mom, that she was in that apartment. Ladies and gentlemen, make no mistake, the evidence in this case will show that Sterling suffered in the last hours and days before his death. His body racked by fever from infection, with maggots feeding on his body's fluids, on the contents of his diaper, laying in urine and feces, soaked clothing. And at that time, his mother wasn't out of state. She wasn't across town. she was in the next room in that little apartment, ignoring his cries, ignoring his basic needs, ignoring her child, to lay in the swing, unloved, uncared for, and unaided.
Okay, so that's just a bit of the prosecution's opening. You can hear the prosecutor going through some of the really grisly, hard to listen to details of how this 4-month-old baby died. We talked earlier about the brevity of the defense's opening. Let's listen to that now.
There's no doubt that this case is a terrible case. It's a tragedy. You're going to wonder what kind of monster could do something like this. The monster in this case is mental health. The monster in this case is depression, postpartum, substance abuse. You're going to hear evidence in this case about Miss Harris, what she was going through, how she suffered from depression, how she suffered from postpartum, and how she self-medicated. You're not going to hear in this case about the typical type of actions you might hear when you hear about child abuse. You're not going to hear about injuries. You're not going to hear about broken bones. You're not going to hear about bruises. You're not going to hear about any purpose on Miss Harris's part to harm Sterling. You're not going to hear about any evil design or any plan or any ill will towards Sterling. You're not going to hear any evidence that she's evil. That's because she's not evil, and this case is not.
Okay, as we mentioned, the very brief defense openings, Linda, you got a chance to listen to them again. You thought she was quite effective, though.
Actually, I did. She was short, but she projected. She was well-spoken. She started laying the groundwork. She's not a monster. You're not going to hear she's a monster. You're not going to hear specific actions like she hit her. It's neglect. So clearly, she's saying, okay, so why did that neglect happen? What caused that neglect? Now, the problem she's got, though, is in our society, we think mothers who neglect children are a lot more responsible than fathers. The penalties for mothers who neglect children, unilaterally, you can see they're much greater when you.
But in this case, both parents, and we saw the first trial trial against Zachary, the father. Both parents are being held responsible.
That's right, because Zachary, even assuming that all this is true, that she has diminished capacity, and she may, we'll see, because they have to prove it. The defense has to prove that. Okay, Zachary was there. He checked on the baby. He knew they have diapers in the corner, new diapers.
And I got to tell you, his defense made me so angry during the first trial when he said that the reason he basically tried to shift the blame to his girlfriend, to the mother, and he tried to say that, you know, he had an issue with changing diapers and that it wasn't part of his culture or something, and so therefore he could not be blamed for what happened.
Well, he could pick the baby up and bring him to the parents' house, which is where the other child is being taken care of so well. I mean, there was a lot of things he could do. That was terrible. I think that was terrible. But he did testify. So what do? We say if they don't testify, they're really guilty. And if they do testify, it's really terrible also.
Well, it'll be interesting to see if she testifies in this. Let's listen now to the 911 call that the father made. Take a listen.
County 911.
This is Zach Cohen. I need an ambulance sent out here to my apartment.
Okay, what's your address, Zach?
107 South Hilltop Avenue in Alta Vista.
Okay, what's going on?
Around 9, my girlfriend went to feed our son, and then about 11 or 11:30, she went to check on him, and he was gone.
Gone meaning?
He died.
Okay.
He's like probably 4 months. I don't know if it's sudden death syndrome or what.
Okay, so you live at 107 South Hilltop in Alta Vista? What?
Apartment 7.
Apartment 7? Okay, and your son is 4 months old, and the last time that you was checked on was 9?
No, she fed him at 9.
Okay.
And she hadn't heard him. She went to check on him, hadn't heard him cry or whatever, and So probably about 11:30, 11:40, she went to check on him. He passed away.
Okay, so that's the story from the father to the 911 dispatcher, that the mother had fed the child, and then when the mother went back to check on the child was no longer alive. Sterling, there he is. That seems like a very hard story to believe, and it sounds like a blatant lie,
right,
to be quite frank.
Absolutely, especially since afterwards she was asked, I believe, when was the child last fed, and did not have an answer. So it is a blatant lie, unless he asked the wife.
Unless she told him that.
She told him that. But I don't think he said that on his death testimony, but maybe he did. But it doesn't matter. You go into a room, there's maggots, there's bugs, there's flies. The child is getting thinner and thinner and thinner, dying before your eyes, and you don't do anything? I mean, that's what really gets this jury upset.
Yeah, I mean, I can't imagine. I'm sure some of the jurors are parents there, to have to listen to this and stare at this woman who did this to her child. Has to be very difficult for jurors just to get beyond that, and then you take in this diminished capacity thing. It's a lot to swallow.
It's a lot, except that a lot of women know about postpartum depression. They know it's real. The old Andrea Yates case out of Texas, where she had been diagnosed, however, before she even had the last child, when she killed all of her children, or 5 of her children. I don't know if we're going to hear that here. I think we'll hear a latter diagnosis after
Most
she was
likely,
arrested.
if she did have postpartum, like the defense is saying, that, since she was into drugs, I can't imagine she was seeking help for it at the time. But we'll see. We'll see. All right. We have to take a quick break here on the Law&Crime Network. We're going to continue to analyze this case out of Iowa. The McStay family murders case, we're also following in that trial. They're on a break today. Actually, they're doing a site visit, so we don't have actual trial today, but we're continuing to monitor developments in that case as well. Stay with us. We'll be back in just a few minutes. Back to that case in Iowa, that really tragic case involving the death of a 4-year-old boy, Sterling Cohen. 4-month-old boy, Sterling Cohen. His mother is accused of murder, and she is standing trial. Earlier this morning, we heard from Tony Frederick, a retired registered nurse and the first responder to the scene. Let's listen to some of her testimony.
Apartment.
Yes.
What did you do?
So I pulled up, and I pulled right up, and I saw a man, a woman, and a little girl, and I got on my car and I went running up to them and said, "Where's the baby?" Nobody was showing any emotion, and the man goes inside, and I said, "Show me." And so he took me inside. We walked in, and we went to the back bedroom. He took me to the back bedroom, and it was dark, and it was stuffy, and there was a stench of urine there. I was looking for a crib. I couldn't see a crib. I said, "Where's the baby?" And he said, "In the swing." His eyes were fixed and dilated, staring straight out. He had blood around his mouth, and I went to check a brachial pulse on him, and his arm was stiff and rigid and cold. All of his extremities were cold. His little feet were cold. His hands were clenched in a fist, and he wasn't breathing, and his clothes were like crusty. After I
did my assessment and realized that I couldn't do anything. I called back into the sheriff's department and asked for the sheriff to come and another medical examiner.
Why did you call the sheriff's department?
Because this was not right. Something was not right here.
Gosh, you know, just hearing from this woman, the first responder, she was a registered nurse. Obviously, she's seen a lot in her life. You saw her get emotional on the stand as she describes seeing this 4-month-old child in such a horrible condition, Linda. One thing that she noted, and that some of the other witnesses that we're going to get to in a sec have noted, is that the parents didn't seem to have, quote, a normal reaction to what was going on. They seemed stoic. They didn't seem upset. They didn't seem crying. I know. Could, you know, and a lot of times the prosecution tries to hint at this as being some kind of proof of guilt. Right. But is that necessarily the case?
No, as a matter of fact, I was having a discussion with one of our trial watchers yesterday about how sometimes even police officers will laugh when they see it. They'll laugh, and they're not laughing because they're laughing because it's a way to reduce stress. So everyone reacts differently. Could he have been in shock that his child died? He did call 911. Could he have been on drugs? We don't know.
Well, in listening to the 911 call, I got the same sense that witness testified to, that there was something cut off about him. The way he described it, he didn't even say the child was dead. That's video, by the way, from a police officer's body cam when he was being interviewed at the house. And what makes that interview so hard to listen to is that there's the little girl he's with. And she's fine. She looks healthy and happy.
And he's holding her and hugging her, and obviously
and he looks loving. And I mean, listen,
something is not right.
Something unraveled here that was very, very dark. Obviously, we're going to find out more about what that possibly could be, especially when we hear the defense's case.
Absolutely.
But let's listen to another witness who was a mail carrier who also responded to the scene.
I walked inside.
Inside what?
Inside the apartment.
And would that be apartment number 7?
Yes.
What did you see when you walked inside apartment number 7?
I saw Tony kneeling down by the baby.
And so did you enter into the back room of the apartment?
Yes.
Prior to entering into the apartment itself, did you see anybody else around?
The parents were outside when I arrived.
And what did you observe about the parents?
They were just very quiet. No tears.
Did you see any children outside?
Yes.
What did you see?
Their daughter.
And can you describe the daughter?
Dark, kind of dark complected. Cute little girl.
You remember what she was wearing?
I do not.
And did you make those observations before you went inside the apartment or after coming out?
Before.
And then you said you went inside the apartment and went to the back bedroom, correct?
Yes.
And you saw Tony kneeling by the child?
Yes.
Did you see the child?
No.
When you were making that observation of Tony, what was she doing?
She was kneeling by the baby, and I went up to her to ask her what I could do to help. And she wasn't performing any emergency care.
What did that mean to you?
That the baby was probably gone.
And this woman's describing the moments right after emergency personnel arrived at the scene. The first responder, the mail carrier, was the second person besides the parents to be there. What do you make of her testimony?
Well, you know, she's calmer, but you can see that it really affected her. It affected all of them unusually, and that's going to be a problem for the defense and the jury, in the sense that this jury is going to need psychological counseling after. We don't see the pictures. We're not showing the pictures, but I can imagine that. Look at her. Look, it's when you see the facial mannerisms and tell even more than what she said.
It's interesting because we had one case, and I can't remember which one it was, but it was one of these awful cases. All the cases we cover are awful.
Right. But death is awful.
Death is always awful. Right. Dead children
Terrible.
particularly awful, where a potential juror actually tried to say that due to the nature of the case, I don't think I can emotionally handle what they're presenting to me, and I want to be dismissed.
I believe that because, about 20 years ago, you couldn't even show TV shows when it involved the death of a young child like this. We've become a little bit more callous, or we're interested in how to stop it from happening, because this is just, it's so egregious. The only thing you can say is that the child hopefully was out of its suffering, wasn't suffering because he was maybe not conscious. That's the only thing you could say here, because it's just terrible.
Well, and to make a point about that, I do, a lot of times people say, well, why are we watching a case like this? It's so horrible, I don't even want to see it. And I understand that,
right.
But I also think that if the public is not aware of what's going on in their own backyard with families like this is not an isolated case.
No.
This is a egregious case,
Right.
but this is happening all across America.
Absolutely.
Child neglect, child abuse,
and drug abuse related
and drug
to having
abuse with
children.
meth and children.
Right.
And so we're shining a light onto what's going on. And if anything, this should fire people up to try to want to do something about what is going on. Okay, we have to take a quick break. We'll be back in just a few minutes. Stay with us. Back to the Law and Crime Trial Network. I'm your host this afternoon, Rachel Stockman, and we are taking you back inside this case in Iowa against that mother accused of killing her 4-month-old little boy. Let's take you now to some testimony from a mail carrier that was nearby and witnessed how that mother reacted after really realizing the child was no longer alive.
When you were in that room and you saw Miss Tony kneeling by the baby, what was she kneeling by that the baby was in?
A swing, a baby swing.
Can you describe where the swing was in the room?
It was up against the wall, facing the wall.
When you were in that room, how did the room feel?
Very warm. There wasn't air.
Was there air moving?
No.
How did the room smell?
Like dirty diapers.
Can you describe how strong the smell was?
Strong.
What do you mean?
Strong as in too strong for the children to be in there.
Was it obvious when you walked in the room, that smell?
Yes.
Did you say that she told you the baby was fine? She fed him last night at 9:30?
Correct.
And you said something in response to that?
I said, you mean this morning at 9:30, I said a 4-month-old would have needed to be fed sooner than that.
And what did she respond to that?
Nothing.
When you were talking to the parents, had law enforcement arrived yet?
Yes. Then Reed Palo came in and he took them in the bedroom, the other bedroom across from where the baby was.
And what did you do at that point?
I left.
Why did you leave?
Because I wasn't feeling too good.
Where did you go after you left?
I went in my car and went out on my route.
Did you stop?
Yes.
Why?
Because I had to throw up.
And why did you throw up?
Because it was so sad. And had I known that child was there all that time, every day I drove by, I could have done something. And that day I was just too late, and I couldn't do anything.
Gosh, that testimony is just so chilling to hear. This woman felt guilty. There she was doing her mail runs every day, going by this house, and a little child was dying. And she feels guilty that she couldn't have done more to save the little child. Very, very, very sad testimony. You could see, obviously, that she got emotional, too. But let's put that, if we can, aside and just kind of talk about some of the substance of what she was saying. Specifically, she talked a lot about how the parents, especially the mother, was reacting, what she said after this happened about the feedings, and then she even said what she thought that the mother should be feeling or should be reacting.
Right. She said,
and as a defense attorney, you said maybe she shouldn't have said that. The defense should have piped in there.
Yeah, you know, I don't. It's a fine line here to objecting, because she said the mother should have been screaming and crying, and many jurors may feel that way.
Of course.
You know. But then if you are on drugs, or if you do have depression, that's not how you react. So maybe, because this is second in court, the defense is saying they did object at some point, maybe a little too late. They did. It was a little too late if they didn't want to get that in. But at some point, maybe you want to use that she has such a lack of emotion that something clearly was wrong with her, because she should have been screaming and crying, and she wasn't.
Gosh, but hearing testimony like this, you know, from a witness that's not a detective, that's not someone, a medical examiner, even though I have seen medical examiners choke up on the stand.
Which I don't understand, but that's
I have seen it, and we've seen it on some of the trials that we've covered here. This is just an ordinary citizen that's all of a sudden put into this scenario where she sees
a juror,
this.
Isn't she?
She's a juror.
She's an ordinary citizen just dropped into the middle of this case with this terrible fact pattern, a terrible situation where she saw the baby, just like the jurors are saying, and that's her reaction. So is that the reaction the jury is having?
I can only imagine, like I said, that some of them, because I honestly feel a little sick now myself. I'm a mother. I have a young child. And just to hear the story of this little boy being neglected like this is very difficult. So we're going to take a quick break from that. We need a break from that. The court's also in break. They're on lunch right now. When they're back live, we'll take you there. And we're going to transition to the McStay family murders case out of California. We have to take a quick break, but we're going to go over some crucial testimony from that trial coming up in just a few minutes. Stay with us. Everybody to the Law and Crime Trial Network. I'm your host this afternoon, Rachel Stockman, and as I mentioned, we're shifting gears right now. We're going to take you to California into the case against Charles Merritt, who's accused of killing a family of 4 back in 2010. For years, investigators believed that they had fled to Mexico and that this was not a case of foul play. Then back in 2013, the bodies of the parents and those 2 young children who you see in the picture there were found in a shallow grave near the Mojave Desert. It was a case that stumped investigators for some time, but finally they pointed the finger at Charles Merritt, who's Joseph McStay's business partner. As part of their case, they had pointed to the home where the McStay family lived as where those murders occurred. Let's listen to some testimony about what prosecutors believe was a bit suspicious about the circumstances at the house after the family disappeared.
What stood out to you as an initial investigator evaluating the state of the investigation when you saw that photograph?
That there were no towels inside the bathroom.
Okay. And is this the downstairs bathroom?
That's correct.
Exhibit number 100. Is that the upstairs bathroom?
Yes, the upstairs shared bathroom.
And what was significant about that photograph when you reviewed it?
Again, no towels.
Exhibit 660 in the top left. That is what?
That's the master bathroom. And there's one hook with no robe, and then a second hook with a bathroom on.
In the bottom left, exhibit number 53, what is that?
That's the downstairs bathroom toilet, where there's a decorative rug chamois on the toilet seat, and no matching floor rugs or any other type of matching set to it. Did that cause you to look at the evidence that was recovered from the gravesites? Yes.
Showing you exhibit number 297 as displayed. What was significant about that?
Looking at the fabric and the way it's depicted in the photograph, it appeared consistent with what would be either the bathrobe, if there's one missing from the hook, or from the matching rug to the toilet seat cover.
Number 297. 293, what was significant about that?
293 appeared to be a towel with a sunflower type print, consistent with a bath towel or beach towel, which I did not notice in any of the other photographs of the residents at the time of search warrant.
Now, the fabric material, fuzzy fabric material 297 and then the towel 293, those were not the exclusive pieces of evidence taken from the grave that piqued your curiosity, was it?
No, they weren't.
There were other pieces of material found, to your knowledge?
Yes.
Okay, so this is a case that, unlike some of the other trials that we covered that wrap up in a week or two, this is a trial that is going on for months. It's already been going on for several weeks, and we're really getting into the details with every single witness. In particular, the prosecution bringing out of this witness that he found it odd that there were no towels in the bathroom. What the heck, Linda, does that have to do with this case?
Right.
Explain this to me.
This is the lead detective, or considered the case detective, apparently.
Yes.
So there was a towel that was found in the gravesite, right? So what they don't have, the prosecution, they clearly don't have anything that matches a towel in the bathroom. So they want to create a suspicion here. I'm suspicious because in the master bathroom there were no towels. Well, it was being renovated, as it turns out, on cross-examination. So of course there were no towels. I saw a towel in the garage in the pictures, from the pictures, and it had a seam and it looked like it could be that towel. So therefore, that came from the house. Where's the science? You go back to the manufacturer. If you see it in the garage, you get that towel and you see if you can match it by a scientific testimony in the lab to what's in the grave. I don't understand what's going on here, and I think the jury gets it. I think they understand that there's no evidence.
And like I said, even if you were able to make that distinction that the towels match somehow, first of all, that would be pretty hard to prove, I think.
Well, well, I don't know. I've seen. I mean, they can tell you whether they can tell you the FBI of a garbage bag. You know, a brand. You know the brand. You see it in the picture. I think.
Right.
You know,
so, but regardless, that's not clear from what happened here. So, Joseph Steers, the former San Bernardino County detective, his testimony.
Exhibit number 48 and 83. Do you recognize those two photographs?
Yes, I do.
How are you familiar with those?
These are photographs I reviewed again from the San Diego Sheriff's Department when they served a search warrant at the McStay residence in Courtroom.
And why did you single out exhibits 48 and 83 in your evaluation of the case at that time?
There was presence of paint cans in 48 on the bottom right corner, along with some painting supplies above it. And in 83, in the garage, there's a couple paint cans, I think, on the right side.
And what is that on top of the box to the left in 83? Showing you exhibit number 267 and 268. Do you recognize that?
Yes, I do.
How are you familiar with them?
One is, number 267 is a black backpack found in the gravesite of the individual, and 268 were 3 items: a paintbrush, a spoon, and a small little paint pen item that was also found in the gravesite.
Okay, so this former detective on this stand is talking about some of the items that were found in the gravesite and talking about how this home where the alleged murders happened, according to the prosecution's theory, the family was renovating, and that there was painter's tape and that there was paint, and both paint and painter's tape were found on the bra and items inside the grave where the family was found.
Right.
Is this significant, Linda?
Well, let me just correct something I said before. I said he was the lead detective on the case. He's not. He was the crime scene detective on the case from San Bernardino. I don't think so, because, of course, the family had been in the house at some point. That doesn't mean the murders are committed in the house. And you take things with you from the house. If she were painting, for instance, and then lured out of the house, come on, quickly, your husband's had an accident. You've got to come really quickly. She just, put something on and go.
Right, and so, this was a family where they were renovated.
They were renovating the house.
So it wouldn't be totally crazy. I mean, it is a little odd that on a bra that there would be paint. If you were renovating a house, usually people don't paint in their
you don't
bras.
know
But
that's where it first came at. It could have been on her clothes. When
it came off on the bra.
You
yes.
don't know because the bodies were a mess in the grave and found over 3.5 years later.
And let's look at the bigger picture of this all, too. Even if it did come from the house and that is where the murders occurred, let's remember that it's Charles Merritt that's the defendant in this. So what the heck does that have to do with him being the one that did the crime?
For some reason, the prosecution was stuck on this, and I don't know why. The murders had to be in the house as opposed to, he actually, he would have taken, my theory would have been he would have taken McStay after lunch to his shed or something, and that's
after they were at the
the family was lured out and they were killed at the gravesite. So I don't understand why we're stuck on this, because this is what's giving the defense the ability to cross-examine so
It's
incredibly.
making the prosecution's case look weaker, because the prosecution is trying to prove stuff that they don't really need to prove in order to, make sure the jurors believe this murder happened at the house.
And explain away like it could have. Well, we can't say it did, but it could have. It could have.
Okay, so this is a very fascinating case. I can tell you Linda is very fired up about this.
Case, right.
So we're going to continue to analyze it here on the Law and Crime Network. We're going to go through all of the important details and important witnesses in all of this, because this is no slam dunk case against Charles Merritt, the defendant. That's some home video of the family, by the way, the McStay family together. It's so hard to hear. The brutality of this case, too, is something to note. And the fact that the prosecution is trying to say one person is responsible for all of this. Stay with us. We'll be taking a quick break. Be back in just minutes. Family murders case in California, to the question of the paint. The paint that was discovered on 8 items, I'm getting tongue-tied here, items found in the grave, and whether that had any connection to the home where prosecutors say the murder happened. You just heard from the detective talking about the paint. Now you're going to hear him undergo cross-examination about that very issue.
First time she went over there, you talked to her about damage burns.
Correct.
And she told you when she entered the house, she smelled rotten food.
That's right here, safe, beyond the scope.
Correct. She mentioned nothing of smelling fresh paint, correct?
Correct.
Then she saw different items on the counter, fruit, eggs, everything like that.
Yes, she saw different items.
And she said she saw eggs in a carton, both whole and broken.
Objection. Hearsay, beyond the scope.
No, Your Honor, this is actually impeachment to Mrs. Blake's testimony. She only said she saw them.
Objection, argumentative. Move to strike counsel's comments.
All right, I'll allow responsible impeachment.
You remember the aspect of how she described it? Eggs were found.
Yes.
And did she not tell you that some were inside the carton and some were broken?
Yes.
And also, Blake recalled seeing a flathead screwdriver and an instrument commonly used to open paint cans in the kitchen.
Objection, relevance.
I apologize. I have to review my report to see exactly what she said.
Okay, so what is the relevance of this cross-examination of the detective? Can you break it down for me?
Yeah,
Please help me.
Break it down. So here's what the mother went over, right, and looking for them and smelled hot food, right? The mother looking for the family, and there were also eggs on the counter. So the prosecution's been going that this had to happen on February 4th at night, right? The defense is trying to shift this to make this happened in the morning, and therefore it's more likely that considering the eggs were on the counter, some were broken, and there was was a paint can open that she may have been painting, that she was lured out of the house with the kids and went running out of the house in the morning. And if it's in the morning, then it may not be the defendant on trial. So that's what the defense is doing, is shifting the time frame.
The time frame and also where this could have happened.
Where it could happen,
which is
absolutely.
an important part of the case that we've been talking about, too.
Okay. The prosecution's made an important part of the case.
Right, for whatever reason that we can't quite figure out.
Right.
Okay, so let's turn, and this has got, you're going to want to stick around for this because Linda's really fired up about this. This is the FBI forensic examiner talking about the paint, because remember we talked about how there was paint found on some of the items in the shallow grave, and that there was paint cans in the house of the McStay family because they were renovating. Let's listen to what the FBI forensic examiner said about whether they matched the paint.
Did you reach an opinion as to the level of association between items 1 and 2?
Yes, I did.
And what is that opinion?
My report reads that those items 1 and 2, could not be differentiated, and therefore they could have originated from the same source. And I give that a level 3 association. What that means is that in all the testing that I did, I could not tell the paints apart. However, I know that there are other paints that could be manufactured that could also be present in the marketplace that could also have those same chemical components to it. So I couldn't tell these apart. I can tell them apart from other paints, but there are other paints out there also that might have the same chemical composition that also look the same physically and chemically.
But based upon all the tests that you ran, they were consistent with each other?
Yes.
Okay. Did you also, in October, receive another paint sample?
In October 2014?
Yes, I'm sorry. Yes.
Okay, so we're going to get to the cross of this witness very soon, but you have just some problems with what she said in direct.
Yeah, I mean, because the paints, the FBI has been trying for 10 years now to make it so that when they do a comparison, this is called the comparative sciences. I look at this side of the jacket and this side of the jacket.
Try to determine if they're the same.
Right? And they, you know.
Nice jacket, by the way.
Thank you very much. So they're trying to do that, and they're having standards. They just did, I happened to have them off the press last week on the hair standards when you do it. And they're trying to make it so that you say inclusive, exclusion, or inconclusive. So inclusion, exclusion, inconclusive. Here she's trying to say, well, I couldn't differentiate them, okay? But you know, let me just whisper. They are made. Most paints made the same way. Well, if most paint's made with those same
then
ingredients,
how can you say that they're the same?
It's not a specific formula. You can't say the same. If it's white paint, I mean, there's white paint everywhere. You know, when you go, I mean, this whole house is painted white. I'm sure other houses are painted white. So that's what's going on. And the cross, we'll see what the cross.
Well, let's see. Good lead-in. Let's listen to that.
You haven't actually seen the items, correct?
I saw them when I tested them.
You saw the actual items, or you saw scrapings from it?
I saw scrapings from it.
So this is an item that's the sledgehammer that the scrapings came from that you tested for one of the 2 items. And this is the bra. The bra is more important to me, since you are an expert on paint. They described the paint on the bra in the report submitted to you as a drop on the bra. Looking at 746A, would you consider that just a drop?
Objection, argumentative, false or speculation.
You want me to say this is a drop of paint?
How would you describe that paint on the bra before you in 746A?
I would describe it as paint.
Would it be more than a drop?
Objection, argumentative.
Depending on how much was splashed onto it, it could be 1 drop. It's paint on a bra.
Is that, because you talked about based on your analysis of that item, that the paint went onto that item and likely cured by air.
Objection, speculation, foundation.
Well, she can answer if she has anything to know.
Did you repeat the question?
In your report, you talked about how the paint scraping that you analyzed, it appeared to be paint that was on that item and cured by air.
I would agree with that.
What does that mean when you put in your report that it's cured by air?
What I mean is that I believe that this paint was wet when it was dropped onto the bra, and then it dried. That's how it got on here.
And do you see any paint on the handle of that sledgehammer that would be consistent with what you tested? If you could take a look and see.
Subject us to speculation and foundation.
Over there, she can look at it and see if she has anything.
So I had pictures of these items in my notes that I was using as well.
Do you have those notes with you?
Those notes were provided in discovery.
No, but do you have them with you? In case you need them for reference, because I have them.
I have a copy of my notes.
Okay. If you refer your notes to help them refresh the memory, we take where it came from.
Okay, so the defense attorney in this cross-examination is making some pretty plausible explanations for how this paint ended up on both the bra and the weapon that was found inside the shallow grave. What do you make so far of the cross-examination?
Well, of course the paint can transfer. Anyone who's painted knows that you get paint all over you, right? I mean, it's ridiculous. What really happens at the very end, she's going to talk about and going to say that, look, she's inconclusive in matching them, that you can't match them to the level that you have to say they're the same, that there are some minor differences, and she keeps emphasizing minor, but there are differences that could not be explained away, okay? And that there's common pigments, when they quote say they're consistent, there is common pigments to the paint because all paint or a lot of paints have the same thing, whether it's oil-based or whatever base
especially
paint
if
you're
it's
doing,
the same color, I would
especially
assume.
the same color. And that she emailed people in the industry to say, could you explain away the differences? And we could possibly explain away the differences, but there's no scientific test to really run them. So the problem I have is that don't emphasize minor. Don't emphasize that, well, there's minor differences. We can't explain the way, and we can't account for them. But they could be, in some regards, they're consistent. That's really shading your testimony to the prosecution, and that's where I had the problem.
And what do you think, basically, that all of the evidence surrounding the paint doesn't really amount to much in terms of the prosecution's case? Because I don't see a clear
I don't
connection.
See it now. Look, if the prosecution believes that murders were committed in the house, they're going to believe that it's the same paint. They don't care whether it chemically matches or not. But I don't know how it gets you to the murders are committed in the house. She painted that paint could have been there wet, and she had it on her bra.
And let's look purely. This is a woman who works for the FBI that has most likely taken the stand before in other cases.
Right.
How did she perform as an expert witness for the prosecution in this case?
Well, juries are very smart, and they heard the and they then, those little tiny things sometimes make a difference, and they know that after an hour and a half of her testifying, what she can say is that it was inconclusive. So, but I don't know where that got them anyhow. But she's going to say, so what? So why
even have this woman take the stand and talk about the paint if you can't even draw any conclusions anyway?
All they really want to say, the prosecution, is that
it could
paint.
be.
It could be there's paint there. It could be.
Okay. All right. Well, listen, this is a fascinating case because there's so many different elements. And listen, a lot of our experts have looked at the details, including my friends here at Linton, and say, does the prosecution really have the right person in this case? Is Charles Merritt really the murderer? We're going to continue to analyze this case. We have to take a quick break. We'll be back in just a few minutes. Everybody, let's take you back to that California court in the case against Charles Merritt, accused of killing that family of four. Things got pretty testy yesterday afternoon when the defense and prosecutor were arguing back and forth, and the judge had to intervene. Let's listen.
Because I was informed by my colleague that there was different testimony, and I can hear my colleague inform them. I told Mr. McGee something that he misunderstood what the testimony was. In regards to the sidebar about the discovery violation, I didn't argue for a discovery violation. I didn't say there was. I'm not sure if I received that.
I understand. I didn't take that as you claiming that they did not give you discovery. You indicated you don't recall seeing it once they indicated they had it. It was a problem, so I didn't see that as an accusation of the discovery violation.
I do want to point out, we are still waiting for the witness list with the addresses. We tried to contact some of the witnesses that they have subpoenaed or as the potential witnesses of the number that they gave us. The addresses in the police reports are not accurate. So we are still waiting for the witness list that we're entitled to. that have the updated, most recent contact information they have for those people so we can contact them.
And obviously we weren't aware of outdated information either, and they haven't even made an informal request going, hey, we tried this address or phone number, it's not good, can you check into it for me? That would have been the courteous thing to do.
The law requires the people to give a witness list with addresses 30 days before trial. They haven't done that yet. There's no requirement that the defense give an informal request for them.
Well, they indicated that they did provide information, and they're saying the information that was provided is no longer accurate information.
The only information they provide is they look in the police reports that were written in 2010.
If Mr. McGee can clarify who he's looking for, we can provide him the most accurate information that we have.
We're asking for information on everybody. The most up-to-date information they have is they're required to do. And just also on the lines of discovery, we received more discovery this week of reports they're writing now that investigations they started after testimony started. And Mr. Gerard, who's back here today, has been writing in 402 that we're going to have the court address for exclusion of witnesses that the people want to call, that they did not get involved in this case until after opening statements. So we are going to address that at a later date. We just want to let the court know.
Well, then you're going way beyond the issue of the next two witnesses.
Yes.
And it's certainly not uncommon for continuing investigation to occur during the trial. So
the court can make that determination once they hear what witnesses they are and what they're based on.
Sure.
Okay, further speculation on this.
So with regard to...
And Your Honor, can we please admonish prosecution? Any more negative comments like that? And I'm going to start asking for suspension. Because his unprofessionalism has been the highest I've ever seen.
Well, the unprofessional conduct, I think, is equal on both sides. The level of speaking objections, the level of arguments with objections, the disrespect to the court in the arguments on both sides is, I think, at least unparalleled in my 33 years. And I am trying to exercise patience and not starting to cite counsel for misconduct and be exceptionally critical of counsel in front of the jury. But my patience is wearing thin.
Ooh, that's not good if you still have a couple months left in your case and the judge says his patience is wearing thin with both sides. And he was very clear to say this is not just the prosecutor, but the defense is also acting unprofessional here too.
Yeah, he said that, and then later on, we probably don't have time to play it, the prosecution got up and at the end of one of the detectives' testimony, he said, have you ever been to Hawaii? And a snide comment. So it continued. Obviously, they're not getting along. Here's the problem. The judge calling the defense unprofessional, the defense is going to say, if there's a conviction here on appeal,
of course,
that this really was, the judge didn't follow the rules, didn't give them, X, Y, and Z. They asked for it. It could have tainted their abilities to question or cross-examine more. And that's the problem when you do something like that instead of trying to resolve it. Okay, which is some judges do. They'll say, okay, let's see if we can resolve this now. They won't
instead of kind of pushing it.
Right.
Because the issue the defense had was over the witness list. They wanted the witness list. And also they mentioned the fact that there was still an investigation, that the state was still investigating this case actively during the trial.
Right.
And that's not entirely unusual. Why it's a little unusual in a case like this is that they've had 6 years to investigate this case. Right. More than that.
More than that. 9 years.
9 years to investigate this case. The fact that they're
almost
still investigating, does it show desperation on the prosecution's part or the state's part?
Yeah, what's happened is the defense has brought us some issues that the state felt they had to respond to this, so they went out and tried to now respond to them. But they should have foreseen those issues. So this is the problem. This is a death penalty case. I can't say that enough. This
guy's life is on the line.
And whether he did it or not is very important. It's important that the criminal justice system, get the right person. And when you have a death penalty, it's important that they're really sure about this. And this whole, this going back and forth and the fighting, and you don't give the witness list, and then you complain about it, is really unseemly in a death penalty case.
And I got to tell you, I've seen things dissolved in trials like this between both sides. The fact that here we are with several months still to go, and the prosecution and the defense are really at each other's throats. At each other's throats, it doesn't bode well. Okay, I am looking over at our other trial out of Iowa. This is the case against Cheyanne Harris, that mother accused of murdering her 4-month-old baby boy. Looks like the officer, the deputy, is back on the stand. He was one of the first responders. He went to the scene and saw that young baby in the swing who had obviously was no longer alive. Let's listen in to his testimony. Okay, it looks like they're showing some photos from inside the home where that happened. We don't want to show you anything too graphic, of course, so we're going to take a quick break. I want to thank my guest, Kenney Baden, who's been with me the last hour and a half. Don't worry, though. She'll be back at 3 o'clock to host in case you missed some of her insightful commentary. She'll be here in just about a half an hour. We're going to take a quick break. Be back inside that case in Iowa in just a few minutes. Stay with us.